Oh, yes. Welcome to Hashtag IP series with your favorite podcast host, Rita Anwurichinda. Welcome, IP friends. Welcome. If you're a first time IP friend listener or you're a returning guest, welcome to today's episode. And this is our 71st episode, journey to our 100th episode. Yeah. So, what do we do here? We talk about everything intellectual property related. So, it could have, say, a fashion related case, but has like a multi layered intellectual property mechanism, such as trademark, patent, industrial design, trade secret, design right, plant variety, geographic. So, whatever the case may be, I am your go to person when it comes to IP stories in Nigeria, in Africa, and globally. I mean, that's the dream and the goal. But yeah, welcome to today's episode. So yeah, let's get into today's conversation. So before I go into today's conversation, I just want to give you guys like a news flash. So sometime last month, Hailey Bieber, Justin Bieber's wife, was sued by a New York clothing company who said that her skincare line was infringing on their trademark. So trademark protects names, words, slogan, sign, symbol, color, smell, etc. That distinguishes a brand from another, in the sense that it's not going to cause confusion amongst the two brands. So Hailey Bieber had wanted to trademark her name, Road, for her skincare line, and then this fashion brand was like, "No, hold up, don't do that." And then they took them to court. So one of the remedies you can seek out when someone infringes on your work is an injunction, asking the court to ban or restrict that person from further using the name, and also stop using it. So news broke out 2 days ago that Hailey Bieber won the first round, where the court was like, "Oh, this is not an infringement. This Hailey Bieber's product is a skincare line. Yours is a fashion brand. There's not going to be." So the injunction claim you're asking for cannot be granted. So the court denied the fashion brand, called Styled Road, from preventing Hailey from using. That's on today's conversation on IP series Newsflash. So let's go into our story, basically. Story. Yeah. So sometime in 2019, yeah, I stumbled upon a post on Instagram by Deola Sage Official, where she was like, "Intellectual property notice violation will be prosecuted." So Deola Sage has this very fancy ashoke, like a new and improved design of the ashoke, which she called the Komole design. She went ahead to do a design right protection and then put up an intellectual property notice restraining people, or like kind of telling people like, "Hey, stay back the hell up, don't infringe on my design." And I was like, "Ooh, this is really bold and very interesting to see that creatives and designers, fashion designers are thinking ahead and considering intellectual property rights." So I decided to do a Twitter series. So this is more like a throwback Twitter series edition of what I've already done sometime in 2019. So the post is dated 23rd of October 2019, and I'll just get into our story. So because we're in the era of ease of reproduction, fast fashion, counterfeiting, piracy. I mean, it's very interesting and important for fashion designers and those in the fashion industry to, consider ways to protect their new and novel design, so they get to enjoy the exclusive right accorded to a fashion designer who decides to register their intellectual property right and commercialize or make money from it at the end of the day. So, first off, what are the types of intellectual property rights that are very important for the fashion industry? First off is copyright, next up is trademark, patent, and industrial design. Now, for the purpose of our conversation, because I am, basically just speaking to fashion designers, I would want to point out a few things. So, as fashion designers, while you're also considering intellectual property, you also need to consider why you are taking the extra mile to protect your pattern or your design, the raw materials, or focusing on your distribution or retail services, the type of market you really want to break into. What are the laws that actually guides that particular industry? Are there requirements or certifications you need to take? Who are the stakeholders you'll be interfacing with or having conversation with? Your market or your business structure, funding, finance, tax. But like I said, for the purpose of our conversation for today, I will be talking about the Deola Sage case. Now, one of the first intellectual property rights I think that fashion designers should take seriously is industrial design. So it's industrial design in Nigeria and design patents in the US. So under Section 12 of Patent and Design Act, it defines design as any combination of lines or colors or bolts or any three-dimensional form, whether or not associated with colors, or if that industrial design has been intended by the creator to be used as a model or pattern to be multiplied by industrial process and is not intended solely to obtain technical results. However, it is not every design that can be registered because they have to meet the basic requirement, which is it must be new and novel and not contrary to any public order. So I don't know how many of you have seen the Deola Sage Komole Candies Ashoke design. I mean, when I first came across her design, I was like, this is really new. So I guess the story is she kind of uses like the residues of the Ashoke to kind of weave and combine them to get what she actually makes. And her designs, other than the fabric, her designs are they are breathtaking. So I had posted a picture. I don't know, maybe you guys can do like a Google search while you're listening to my conversation about the difference in the normal Yoruba Ashoke and the Deola Sage Komole Candida Ashoke. The Komole Candida is Deola's collection, and she began using that sometime in 1998. So that was more or less like her own journey of innovating or making a difference in the fashion industry in Nigeria. Now, in order for your work to be considered to be new, you must evolve the idea of novelty. That means it's never been seen, either the pattern, the shape, or the ornament, visual appearance of that design. It's never been seen anywhere. And I'm sure that a lot of people of my IP friends and listeners will agree with me that when Deola Sage started putting out her own version of Ashoke, people were very interested to see, they were intrigued by the visual appearance of her own version of the Ashoke, and also the combination of colors and lines and patterns and everything. Now, as a fashion designer, it's very important that you protect your designs. So the developed countries have seasons. So if you're sewing or making or designing, say, a winter collection or a summer collection or autumn or fall collection or a spring collection. So you also now have to be 2 steps ahead of people that want to steal your designs at the end of the day. You also need to include the protection of the industrial design for each of these items, as well as searching and creating relevant and captivating names for each of the design. So what now makes your design not to be registered as an industrial design or enjoy design right protection in Nigeria? Now, what the law provides is that if before the date of publication for registration, your design had been made available to the public. So let's say you participated in a fashion show, or you launched your collection, say, on an Instagram live, or as we are currently doing now in the virtual reality space. You're like, ooh, let me delve into metaverse, and you just do publish your design there. And at any time, by means of description use or in any other way, public is interpreted to mean an exhibition in an official or a recognized official exhibition like fashion shows, runways, and the rest of them. You participated in all of those things. Your design may not enjoy protection because it's not considered to not be new, and you know that for your work to enjoy protection, it must be new and it must be registered. Registering it gives you a term of protection for 5 years, which is subject to renewal for 2 consecutive periods of 5 years. So, but then again, it's very important for me to state that you have a grace period of 6 months in the event where you fail to register your design. So you have to, like we say, regularize your registration. So you have to make sure that 6 months doesn't elapse and then you're just out in the wind and, with no protection and the rest of it. So the next type of IP that I really enjoy talking about is trademark. Now, trademark, while talking about the IP series stories, I gave a brief summary of trademark, but I'll just go over it again. Trademark protects words, name, sign, slogan, symbols that are used in relation to a fashion business. If it's for service, it's called a service mark. Trademark as a type of intellectual property mechanism is used to protect brand names, symbols, words, signs. So, for instance, in our case study, we're talking about the Komole Candida. And in Nigeria, trademark is governed by the Trademark Act, where you are required to meet the basic requirement as provided in Section 9, which is your mark must be distinctive. So, basically, when you meet a trademark attorney, or you're talking to an intellectual property law firm or a trademark agent, they have to ask you a series of questions to determine if your mark is distinctive enough, if it's not generic or common, if it's coinful or arbitrary, whatever the case may be. They will properly guide you on the right type of mark to register so that your registration scales through. And now, when you do that registration, it gives you exclusive right to use your mark, to license it, to go into a co-branding or partnership arrangement. And trademark is considered to be one of the most valuable tools to secure your position in the online market, because if people don't know your name, the name of your brand, they won't want to buy your product. And it's a good thing that we're seeing a lot of fashion designers springing up in Nigeria, both on Instagram, and thanks to all these short form videos now, able to see how fashion designers their before and after, behind the scene, where they sketch the design to coming up with the design and putting all the fabrics together to make it a beautiful piece at the end of the day. Now, trademark and fashion includes having your trademark name on the tag or on the piece of clothing. So if you look at your clothes, you see that the brand name is either put on the dress or the cloth or the shirt or whatever it is. Now this is a process known as trademarking. Now, if you look at the luxury fashion case between Gucci and Guess over the use of the interlocked G. Now that case commenced in 2008 and was only resolved in 2018. So you see that it's only that in Nigeria that we have a lot of cases sitting down in court. I know there's another case I'm currently reviewing that has been in court for over 20 years. I have also reviewed a case that lasted in court for 25 years. So there are issues with litigating a case, but then we need these litigation cases to be used as precedent or examples when we have dispute. Now, if you Google famous fashion brands, you see a lot of foreign brands, their names with their logo assigned. Now, those are all trademark. What does it tell you at the end of the day? Now, what this means for you as a business person is that exploring trademark gives you an edge in the market. It also positions you in the market as, kind of puts you in the eye of the consumer, where you are appealing. Your logo, the phrase, illustration you use, like Nike and the Adidas, Gucci, Chloe. I know we have good Nigerian fashion designers, the Maya Tuffles, Tubo. Oh gosh, I think I'm forgetting a lot of names right now, and that's not funny or fair. But yeah, this kind of things, shows that the brand in question is big on brand protection, because intellectual property rights are created by laws, which is what you use to, follow. You follow them to give your business like an edge. It also shows the effort you put, in your business name and thinking about your brand, and also goes to show that you have long-term goals for your brand. And next up is patent. Patent case I'm going to talk about. I learned about this in a fashion training I participated in I think 2018, 2019. I would say 2019, yeah. Because it kind of went to show how creative fashion designers are, because you really want to make a good impression. Or let's use the current Gen Z word, and you want to go viral. So take for instance a Kari dress. I know when Olivia Yes wore the dress last year at the Miss World competition, it went viral because people were amazed, like, how did this fashion designer use cowries to create a dress that could be worn. Even when trying to remember the name of the lady, where she did like a 3D model fashion runway during the pandemic, and people were like, oh my gosh, really? And all of those innovative works out there. So I think the one that kind of stood out during the lectures was talking about the famous Zendaya. If you're a Zendaya fan, please say hey. Yeah. So Zendaya wore like a Cinderella inspired dress to the Met, and it was one of the best dresses or designs for that year. I'm going to also talk about benefits of you actually registering your trademark. It also kind of discourages third parties from using your mark that may confuse another person's own. It also enables a business trademark to be applied nationwide, because trademark is territorial in nature. So when you opt for regional registrations through the OAP system, you can check out the podcast episode I did that with Amela Tada. We talked extensively about OAP. I'm yet to do the Aripo version, but yeah, you can also consider Aripo version when talking about regional registrations in Africa. You can also do the international registrations through the WIPO system or the Madrid system, the Hague system, Paris Convention, and the rest of them. Explore all of that. It also grants your business the right to sue for damages against unauthorized users of the mark. So the same way Deola was like, yo, any violation or violator of my design will be prosecuted. it may have seemed extreme, but it was like the right thing for her to do at that point in time. Then next up would be trade secret. So I know another thing that I did notice was that while I was, kind of doing a research, how can fashion designers protect their trade secret? Trade secret in the sense that your fashion brand can, like the process in making a particular product, say an earring or a dress or a shoe, whatever the fashion accessory may be. Maybe so. I watched the video of the carry dress, how it was made. So those process where they did all of that. Even there's a Dior video as well that I watched that showed the before and after, like behind the scene of how they came up with the Dior bags and the rest of them. So yeah, I think I've kind of covered all the intellectual property rights as it relates to the fashion industry. So I know I had asked this question at the beginning of this recording, but I'm just going to say it. So what we are trying to say in essence is that the Deola Sage Komole Candida meets the first condition of it being new because it passes the second test on public morality, as well as the new designs are not immoral but beautiful, elegant, and the style mixes both the traditional and modern design. What can fashion designers do going forward? Make sure that you are basically protecting yourself. So when you are employing staffs, if you're going into a partnership with anyone, if you have a website or an app, make sure that you're putting in the right or specific policies, such as your refund policies, your shipping policies, your delivery policy, cookie policy, terms of use, um um then contract for employment. Make sure that when you're hiring people, you're specifically stating that they're being hired to design for you, so you don't have issues where your employee leaves you at the end of the day and you end up losing your design rights protection. You're not even protecting yourself. Make sure that if you're also opting for, say, a white labeling model, make sure that it's properly documented. Figure out the industry that you really want to break into. Know that you can commercialize your design where you're going into a licensing arrangement or collaborating, or you want to use an influencer to market your fashion design or your ready to wear clothes, whatever it is. Then also, while doing that, make sure that you have like a company handbook or workplace policy that kind of states what should be done at your place. If you're looking for ways to also fund your business, have a proper structure on how you want to grow your business from ground zero to being a well-known fashion brand. Don't rush the process. Explore technology. I mean, we're in the fashion tech space now where technology is used for a lot of things. For instance, now you're seeing fashion in the metaverse. You're seeing fashion brands fighting to protect their trademark. For instance, the Rothschild Louis Vuitton case is a case that all fashion designers and also practitioners or stakeholders in that sector should be on the lookout for. Then also pay your tax. So yeah, I think that basically concludes our conversation for our throwback series. But yeah, thank you guys once again for listening. Don't forget to subscribe. Don't forget to share, like, and let me know your views. And don't forget, if you have stories you want me to check out to talk about, please let me know. Send me an email to ipseriesinfo@gmail.com. You can also check out other episodes where I've talked about fashion related cases. So I guess I'm just gonna stop here for now and see you guys in the next episode. Bye.